Good evening, everyone, and welcome to our Ecclesiastical Law Society lecture this evening. Happy Easter to you all. I'm just going to dive straight in and introduce our lecturer for the evening, who is the Senior Advisor in the Legal Department of the National Council of the Church of Norway, and also lecturer in Church Law at the Norwegian School of Theology, Religion and Society. Andreas has been an active member of this society, the ELS, since 2014, and he's also vice chair of a sister organization, if you like, the Norwegian Society of Church Law. The topic of tonight's lecture is the Church of Norway before and after its separation from the state. And Andreas is not only the ideal person to be talking to us about this, but it's also, I think, perhaps the ideal time for him to do so, because he's recently submitted his dissertation on this very topic as part of his LLM in canon law at Cardiff University. So it's great to welcome you, Andreas, to give this lecture online, and we look forward to hearing what you have to say and to sharing some conversation and questions afterwards. So I hand over to our lecturer, Andreas Aarflot.
Thank you very much, Russell. Hello to everybody. I will start by sharing my screen so that you will have something to rest your eyes on while I speak. Yes. I thought I would just start with the basics about the Church of Norway. The Church of Norway is an evangelical Lutheran church. With the Lutheran Reformation was introduced in Norway by royal decree in 1537. And then from that time on, the Church of Norway has been an evangelical Lutheran church. About 3.6 million members are registered as church members in the Church of Norway. That is there are 5.4 million people in Norway, living in Norway. So the members of the Church of Norway amounts to about 68% of the Norwegian population. And the basic unit of the Church of Norway is the parish. So we have 1,164 parishes, and they are organized into deaneries and dioceses, and we have 11 dioceses with 12 bishops. So the last bishop is the presiding bishop, who has his cathedral together with the Bishop of Nidaros in Trondheim. The Church of Norway also has a General Synod as the highest authority of the Church. The General Synod was introduced in 1984, and it is now the highest authority. Previously, under the state church, legally speaking, the king was the highest authority of the church, but that is no longer the case. The Church of Norway is also part of the Porvo Communion. So it is a communion, a church in communion with the Church of England. When I speak about the historical development of the relationship between church and state in Norway, there has been a long gradual development over time where there has been different steps where each steps has led to what I would call or categorize as the separation between church and state in Norway. So in 1975, just as background, there was a public commission recommending to separate church and state. But when the government discussed this, they concluded that the relations between church and state should be continued for the reasonably foreseeable future. However, it was prepared to go to the outer limits of a reasonable understanding of the possibility of decentralization and delegation to the church. And one of the important steps was the establishment of the General Synod, being the highest representative body of the church, being able to speak on behalf of the church itself, which was established in 1984. And then gradually, the state delegated authority to take decisions on liturgy and different types of decisions from the king to the General Synod and other church bodies until the Church Act of Norway was approved by the Norwegian Parliament in 1996, and at that time the track by delegating was really exhausted, so there was no more decisions to delegate, but there was a need or a renewed call for disestablishment or separation between church and state in Norway. But before I go on with the reforms, I thought I would go look closer on the constitutional provisions about the state church before 2012. For one, the Norwegian Constitution, Article 2, said two things. One was that all inhabitants of the realm shall have the right to free exercise of their religion. The other part was that the evangelical Lutheran religion shall remain the official religion of the state, and the inhabitants professing it are bound to bring up their children in the same. So that was the basis of the evangelical Lutheran religion, that is expressed by the Church of Norway as the official religion recognized by the state. Additionally, the king had a special role in church government. In Article 4 in the Norwegian Constitution, it's stated that the king shall at all times profess the evangelical Lutheran religion and uphold and protect the same. The king also was responsible to ordain all public church services and public worship, all meetings and assemblies dealing with religious matters, and ensuring that public teachers of religion follow the norms prescribed for them. When the Constitution spoke about the king, originally in 1814, when the Constitution was adopted, the king referred to the king personally. However, gradually over time, the king in the constitutional texts was recognized as the king in the Council of State after the introduction of parliamentarism in 1884 and onwards. So when the Constitution, for instance, in this article speaks about the king being responsible for ordaining all public church services and public worship, it is a reference to the king in the Council of State. And another role of the king, that is the king in the Council of State, was to choose and appoint, after consultation with his Council of State, all senior ecclesiastical officials. So all senior officials, that is, senior civil servants, were appointed by the king in the Council of State. This meant, for instance, that all the bishops were appointed by the king, and the same applied to the deans and rural deans. And until 1989, it also applied to the parish priests. But in 1989, this was the appointment of parish priests were delegated from the king to the diocesan council. Because the king in council would consist of partly members of representing all religions of the realm, there was a requirement that more than half the number of the members of the Council of State were obliged to profess the official religion of the state in order to be able to ensure that there were actually church members participating in the decisions of the Council of State. For instance, the appointment of bishops would only the members of the Council of State who were also members of the Church of Norway were able to participate. And that meant that the king in the Council of State was the highest authority in the Church of Norway, at least legally speaking. The church and Storting, or the parliament, was regulated. The Church of Norway was regulated by the constitution, the state church articles I have just talked about, as well as a separate act of parliament or act of the Storting, the Church of Norway Act from 1996. And the Church of Norway was also financed over the national budgets. But in 2006, a report recommended to change the relationship between church and state. The majority argued that the state-church system dated back to a time when there was a more homogeneous society, and that the state-church system was no longer sustainable, as well as the need to put a stronger emphasis on the equal treatment of all faith communities in Norway. In addition, the Church of Norway's right to self-government was underlined. For instance, when the king in council appointed bishops, the king was not obliged to take the first name on the list submitted from the church. The king could choose between the three candidates submitted from the church. So there were several times that the king in council appointed bishops against the recommendations from the church, which spoke to the question of the Church of Norway's self-government over the important decisions in appointing their own leaders. So based on the public report, there was the different political parties of the Storting came to the church settlement of 2008, where they all agreed on a political agreement. It was all the parties agreed to it, so it was a compromise. The compromise included would entail to start a process with a goal to transfer the appointment of bishops and rural deans from the Ecclesiastical Council of State to bodies of the Church of Norway itself. However, to ensure that the church bodies was democratic enough to be up for the task to appoint the bishops and other church leaders, a condition was set in the agreement. First, a democracy reform within the Church of Norway needed to be successful. So the democracy reform would mean that previously the parochial church council members were made up the electoral college for those electing the diocesan councils as well as the general synod. But the democracy reform would entail that all church members of the Church of Norway on the electoral roll, so to say, would be able to elect the diocesan councils and general synod members. So it was an introduction of universal suffrage in the Church of Norway. In addition, the church elections were supposed to be held at the same time and in the immediate vicinity of the public election polling stations. So in every parish, the parishes would need to coordinate with the public elections to ensure that church polling stations were in the immediate vicinity of the public polling stations, so that the voters voting in the public elections could easily go from one polling station to another without making that much of an effort. There were some other details in the democracy reform, but if the democracy reform was considered successful, the political parties agreed to transfer the appointment of bishops and other senior ecclesiastical offices to the bodies of the church and to make the constitutional changes. Luckily, the democracy reform was considered successful by both the state and by the General Synod itself. So in 2012, there was a constitutional reform where the Norwegian constitution was amended. The state church articles were either repealed or amended. So one part of it was that some felt that if the evangelical Lutheran religion would no longer be the official religion of the state, there would become a value-based vacuum, or a place where the constitution would no longer be based on any values. So therefore, a part of the compromise was to include an article stating that our values will remain our Christian and humanist heritage. This constitution shall ensure a democracy, a state based on the rule of law and human rights. The king would no longer have a special role after 2012. However, I included a quote here from the king himself, speaking to a journalist where he's cited in a book written by a journalist. And the King Harald of Norway says that he was so bold that he asked the government to keep the sentence in the constitution that says that the king shall profess the evangelical Lutheran faith. Therefore, it remains also after the separation between church and state. I think it was and is very important for many. So there was actually a rare intervention from the king, where the king asked the government to ensure that the constitution would still include a provision stating that the king shall at all times profess the evangelical Lutheran religion. So that was kept after 2012 and is still part of the constitution. But this applies to the king personally and not to the council, the king as the council of state. The king, because although there were made constitutional changes in 2012, the normal legislation or the act on the Church of Norway was not really substantially changed, with a few exceptions. So the state church system continued in many respects also after 2012. For instance, the king in council would still be the head of the executive and the highest employer of the civil service. So as the priests would continue to be, they would continue to be civil servants. The king would still, as their employer, have powers, for instance, considering appeals relating to dismissals, or in the cases of senior officials, also to be involved in the dismissals of the senior officials. And the king in council would also pass regulations as an employer would. So this was at the same time when the king in council would no longer be obliged to be consisting of members from the Church of Norway. So the king in council were no longer an ecclesiastical body, but still continued to have some functions. And legal writers has expressed that it was by this it was primarily the freedom of religion of the Church of Norway itself that was threatened, which is also the reason why there was this reform of 2012 was followed up by other reforms. But another important article was Article 16, stating that all inhabitants of the realm shall have the right to free exercise of their religion. The Church of Norway, an evangelical Lutheran church, remains the folk church of Norway and will as such be supported by the state. Further provisions as to its order will be laid down by statute. All faith and life stance communities should be supported on equal terms. So after 2012, the diocesan and national church institutions continued to be bodies of the state. Deans and rural deans were appointed by the diocesan council, and bishops were appointed by the national council instead of the king in council, but the clergy remained employed by the state, although appointed by church bodies, which were also bodies of the state. So there was a need for further reform. And in 2017, there was a legislative and administrative reform, which consisted of a reform amending the Church of Norway Act. The Church of Norway, as such, was established by statute as a legal entity. And as a legal entity or juridical person, the state were able to transfer those who had been employed by the state as civil servants from the state service to and transfer them to being regular employees of the Church of Norway as a legal entity. So this the purpose of the bill that proposed this act was to achieve a clear separation between the Church of Norway and the state, to ensure the church's rights of self-determination and a larger degree of equal treatment of other faith and life stance communities. However, the Church of Norway Act, an act of distorting, continued to regulate the church's organization, the structure, different bodies, territorial reorganizations, and elections. At the same time, the state transferred or delegated authority to the General Synod to pass secondary legislation on several fields where the state had previously, for instance, the king had provided secondary legislation himself, or in the council, that is. After 2017, because the Church of Norway Act was not repealed, the king and ministry retained some statutory functions, and this was relating to territorial reorganization, approval of new church building, and closure of church buildings, although some of the decisions were delegated to either the bishop or the diocesan council. So although this step had included further separation between church and state, personally, I was employed in the National Council also before 2017. So I went from being a civil servant employed by the state to becoming an employee employed by the Church of Norway, which was a great. For me, it felt like a clear separation between church and state, so to say. But there was still quite a lot of provisions the state provided about the Church of Norway, including its organizational structure. So there was a need for further legislative reform. The majority of the Standing Committee of the Storting, in their recommendation to the Storting for the Act, they explained that a clear goal of the Act was to ensure completion of the separation between church and state. So the reform of 2021 included the adoption of a Faith Communities Act. That is an act regulating all faith and life stance communities in Norway, including the Church of Norway. The Church of Norway Act was repealed, and a separate chapter in the Act was kept with 8 short sections on the Church of Norway. These sections provided a framework for the Church of Norway being able to organize themselves. It included a section on the purpose of the chapter in the Act. It included provisions on the parish and the Church of Norway as juridical persons, legal entities, and which bodies would act on behalf of the parish. The parochial church council would act on behalf of the parish unless there was established another body for the parish, and the General Synod will act on behalf of the Church of Norway as a legal entity unless the General Synod establishes other bodies. It also contains a section on the General Synod's powers, provisions on church elections and ecclesiastical voting rights, financing of the Church of Norway, church buildings, and something on the ministry of priests and bishops, as well as which basically says that there shall be a priest for every parish, or there shall be, that is, each parish shall be served by a priest, and each diocese shall be served by a bishop. And there is a provision laying a foundation for the Church of Norway's membership register, because that is a register containing quite a lot of personal data about its members. It's good that it has a clear legal basis. So the General Synod is described in the Act as the body that determines the Church's foundation and doctrine and all liturgies and books of service. And the General Synod may issue detailed provisions as to the Church's organization, territorial reorganization, ecclesiastical bodies, and on elections to these bodies. So this means that it is now up to the General Synod to organize the Church of Norway and issue a church order, that is the constitution of the church, and determining what bodies, what levels of territorial organization the Church of Norway shall have. The king after 2021 is a regular member with no special functions, but he has to be a member of the Church of Norway. And in 2020, the Crown Prince Regent, the King Harald, had to send his apologies. He was on sick leave, so the Crown Prince Regent attended the General Synod and took a photo together with the bishops and the moderator of the National Council in 2020. So although he does no longer have any functions, he still attends some of the, for instance, the consecrations of bishops, and he here also the inaugural meeting of the General Synod for the term of 2020 and to 2023. Finally, I'll just say that the Church of Norway is financed by the state and the municipalities, but the state also funds 724 registered faith and life stance communities in Norway, with approximately the equal amount per member as the Church of Norway. So that was a bit quick, but what I had to say about the Church of Norway.
Well, thank you, Andreas. That was absolutely fascinating talk. The Church of Norway is not a church I know a huge amount about, but from your lecture, already just seeing how many commonalities there are in the structures, the territoriality, the episcopal ordering of the church, the historic establishment, and then these tensions developing over time between the right of a church to be self-governing and those historic establishment expectations and restrictions and liabilities and the tensions, and so much of what you've been talking about, I see in many cases parallel with things the Church of England has thought about and wrestled with, and really fascinating. And to some degree, obviously, the Church of Norway has taken a different direction from the Church of England I'm familiar with, and yet so much of it still seems so similar. I'm sure there are going to be questions from people here. I wonder if I could kick off. I've got at least two questions I'm burning to ask, but maybe the first one, I'm really interested in what you mentioned about universal suffrage in the voting, because we had last year, the General Synod of the Church of England was an election to the 5-year session of the General Synod. Great deal of interest. Particular issues were motivating a lot of people about sexuality, about parish structures and funding. Very large number of candidates. But whereas most clergy not me actually, but most clergy can vote, but the minority of lay people only can vote. Only deanery synod members, you know, 2 or 3 a parish, can vote on the general synod. And so many people have said we really should, you know, all members of the electoral roll of the parish should be able to elect directly to general synod. So I wonder if you could say a bit more about that, comment on how it works practically. What are the criteria as to who can vote? And what's the sort of take up? Do you have any idea what the percentages are and how interested people are in the elections? Because in my imagination, I think everybody would suddenly become very interested in it, but perhaps it doesn't work like that.
Sure. The universal suffrage was introduced in the elections in 2009 first, and the criteria was simply that you needed to be a member of the Church of Norway. So there, in the Church of Norway, we don't have a requirement to be a communicant member or so on. The only requirement is that you are a member and you would like to participate in the elections. So the elections would take place. The members would be able to vote both for the parochial church councils as well as the lay members of the diocesan council and the general synod at the same time. As this was coupled with the requirement that the polling stations would be at the same time and in the immediate vicinity of the public elections, this meant that all the parishes had to really gather many people to be able to administer these elections, because of course a parish might have problems with providing voluntary personnel to really staff these polling stations. But that was actually a requirement, and still is, that it will take place at the same time and in the immediate vicinity of the polling stations, meaning that if the polling stations for the general elections will be open for 1 or 2 days from the morning until the evening, then the parishes also needs to be able to provide polling stations in immediate vicinity everywhere in the country. So it has been a massive organizational venture. For the next election, we're trying to introduce electronic voting, digital voting. So that might be a possibility to lessen burdens on the parishes relating to that. The number of percentages who has participated has varied between around 11 to a top number of, I think, if I remember, it was, if I remember correctly, the top number in 2015 was 16.7% of the members of the Church of Norway. So if you compare to other elections, some would say that, but that's a very low numbers. That's not really that many participants. But of course, if 500,000 members or so participate in the church elections, my view at least is that it's really a great turnout, even though we could in principle have 3 million members participating. It's still, these are the members that will take up their role and then vote in the elections, which I at least, and I do work for the National Council also on church elections. I think it's a positive thing that our members are so engaged that, well, a large number of our members are engaged and would participate in the elections.
Sure. Thank you. That's really fascinating. Really interesting to hear. I do have another question I'm itching to ask, but I just want to say to everybody else, if you have a question, please do either put up the hand or the thumb. Was it the hand or the hand, isn't it? Put the hands up on your Zoom panel, or type something into the chat, as that would be great to get some more questions. While people are thinking about who's going to be brave enough to come forward with the first question, I also wanted to ask, on one of the slides, you mentioned that as things have now settled, the General Synod isn't supposed to make decisions or give instructions in individual cases that are up to the bodies at parish level, so not to kind of intervene from on high. And I'm really interested by that. I mean, just as one example, again, to be topical in the Church of England, 2 years ago, while it was because of the COVID lockdown, although it was still legal for clergy to go alone into the church to say the prayers and ring the bell, the hierarchy purported to instruct the clergy, parochial clergy, not to do so. And then the question was raised, do they have this power? You know, this was the decision for the local clergy. I mean, putting the rights and wrongs of that to one side, it seems to me that this principle is a really key one. But are these the decisions at the different levels? Are they enumerated? Is there a list saying these are the decisions to be made at parish level, these at diocesan level, or is it left a bit more woolly?
Well, the parochial church council acts on behalf of the parish in all matters that is not laid to another body of the parish.
Right.
So in one sense, it's a bit woolly, because the parochial church council has a mandate to do everything that could nurture the Christian and diaconal principles within the parish, so there are a list of some things, but really the parochial council has the autonomy to also come up with other decisions, as the parochial church council also acts on behalf of an independent legal person. So it's free, for instance, to establish a nursery, and because that is part of the Christian mission, or may be seen as part of the Christian mission, and that they are free to do so. So it might be a bit woolly, but it's rather a principle that the General Synod should organize the church and say which bodies do we have, which bodies does the parish have. For instance, the parish might have both the parochial church council, but also a joint parochial church council for several parishes, and then divide the different tasks or authorities between these different bodies. So generally, the church order organizes the church and divides the different responsibilities between different church bodies at different levels. But the what you mentioned about the possibility to instruct, not to instruct, is really an important provision, ensuring that the parish has some independence also from national bodies.
Fascinating. That's really interesting. Thank you. Well, we've got a question from Ed Moore. He's written in the chat, but I wonder, Anne-Marie, if we might be able to get Ed to ask his question direct to Andreas. Ed.
I think somebody has just unmuted me, and I've put my video on so you can have the full experience. My questions probably should be the reversed around to how I wrote them. The first one is, do you think it was the separation of the state and the Church of Norway was actually a positive step as far as the church is concerned? And secondly, bringing the question out of your country, is it a step that you would recommend for the Church of England?
Yes, in my view, the Church of Norway has been strengthened by the change. I would stress that the Church of Norway has really been one of the actors arguing for the change, also to ensure that the church has the ability to self-govern, be able to take decisions of government itself and not on behalf of the state. So after these changes, the Church of Norway has really been conscious as an independent folk church in the civil society, as something we have been able, the church has described itself as now. At the same time, there are, when you are part of the state apparatus, you are also always on the list of, for instance, when the ministries has governmental proposals to amend legislation, for instance, then when they send consultations, then they used to send these consultations papers automatically to the Church of Norway as well. But now they mainly send to other public bodies or other more known organizations within their field. So sometimes the Church of Norway gets are not noticed in these lists, but compared to the possibility to be able to ensure self-government, I think the Church of Norway has really been strengthened by this change, and also the other faith communities, the dialogue with other faith communities in Norway has been improved by the fact that we are now treated more equally. It's not only the Church of Norway that has been favored or privileged. Whether I would recommend the same for the Church of England, it's difficult for me to take a position on, really. Yes.
Sure. Well, we won't press you to that, and Andreas, if you understand that's a difficult one to ask. We've got a couple more questions appearing. So the first one from Joanna. I wonder if Joanna could ask her question.
Joanna. Hello, can you hear me?
Yes, we can.
Good. Yes, it was just interesting what was said about in the Act that each parish shall be served by a priest. I was just wondering whether that meant each church was in the wonderful position of having a priest, or whether it was similar to us here in England, where a priest would serve several churches in a cluster or benefice or similar organisation.
The legal provision really provides more that one priest may serve several parishes. However, the Church of Norway receives quite a lot of funding to ensure that we have ministers or priests that will be able to conduct services every Sunday. Well, in the really remote parishes, it's not possible to have a service every Sunday. But I would say that this provision ensures that we have, at least at present, enough positions to provide quite a good service of the or ministry to the different parishes.
Thank you.
Well, I think that the next question carries on the same theme of financial matters. Sue, I wonder if you'd like to ask your question.
Andreas, thank you very, very much. That was really, really interesting. My sister, having lived over there for many years, I've seen this personally many times in Norway. I'm just fascinated at the potential implications of disestablishment with the church buildings, because certainly the church buildings in this country are so very expensive to maintain. Quite a few people regularly say it would be very handy if the state would take them over. But Norway is doing, it seems, the reverse. I know that Norwegians pay tax, and part of their tax is in effect a financial transfer for the maintenance of the church. And since the act that Your Faith Communities Act, that means that a wider range of faith institutions apart from the church are supported, which presumably is going to actually increase the burden of tax. So I just wondered whether there was much resistance to the state in effect continuing to support the cost of church buildings, or whether that's less of a problem because they're less expensive to maintain.
Yes. Really, what has happened with finances, and the reason why I didn't speak that much about it was that the system financing the Church of Norway has been the same, is the same now as it was when we were a state church, basically. The Section 14 of the Faith Communities Act states that the municipalities has an obligation to provide grants, for instance, to ensure that it's possible to conduct services in the church buildings. That is to ensure a proper church maintenance, the same way as it was as when we were still a state church. However, the reality is that the municipalities' budgets, they would need to cover many financial posts, like the financing the welfare state. So they are under pressure, and therefore, there has been an estimate that the church buildings need, I think, almost what equals to £1 billion in order to be up to date everywhere. So there is a so the system hasn't changed, but and in reality, the municipalities has an obligation to provide funds for the maintenance of church buildings, but they have not really done that until now, and there is a lack of funding these things. However, the Norwegian Church Endowment, which was the remnants of the property confiscated by the king with the Reformation, to simplify somewhat, it is a fund or an endowment that with the separation from the state, it has been decided that the equal value to that fund will go to a new effort of maintaining church buildings, old heritage, which are valuable from a heritage perspective, and it hasn't really been something that that has been opposed by anyone. Rather, some political parties thinks that because the Church of Norway, when we are funded, the other faith communities also needs to be funded on the same amount. Some political parties argue that public funding should not go to, for instance, Muslim faith communities. So that's another part of the question.
That's
But
right.
Andreas, I mean, it was a really, really interesting talk that you've just given us, with a lot of food for thought. But you said something very interesting when you said that you think the church has been strengthened by the separation from the state. And how has it been strengthened? Would the ordinary person in the pew think that? Would the clergy think that? What are the issues that have arisen? I just don't understand how you're defining that it's been strengthened.
I think it is partly about self-confidence, that it stands on the church is more confident to speak publicly about what it means to maybe oppose governmental positions on different issues, although it has also had a prophetic voice also as a state church. But I think it might be able to more freely speak out on what on issues in society from a perspective, from a Christian perspective, than what it used to do when it was a state church.
So do you think the ordinary person in the pew feels like that? Or is that something that the clergy, the hierarchy, the conclusions that they've drawn?
I'm not sure if this change has really registered with everyone in the pews. Actually, in some polling or some surveys, there has been some feedback that people has not really noticed that the Church of Norway has been separated from the state almost, because it has been a quite seamless separation, and there has been no this endowment relating to the disestablishment or the separation.
Well, thank you very much indeed. But it has been a really, really interesting talk. So thank you for that.
Thank you very much for the question. Unless I've missed any, I don't see that we have any more questions in the chat, unless anybody wants to signal for the last moment. Well, as many of those asking questions have said, Andreas, it's been such an interesting topic, and you have a complete mastery of it. So we're so grateful to have been in your hands, guiding us through these changes in ecclesiastical law and constitutional changes in Norway in recent years. As you already knew, of course, and have picked up even more from the questions, perhaps, for those of us in the Church of England, it really makes us think. In these islands, we've got the example of Irish and Welsh disestablishment, and certainly you just mentioned disendowment. That was very much part of those disestablishments. And we've got the established Church of England and Scotland established in their different ways, and all of that already, I think, shows that establishment or disestablishment isn't a kind of one size fits all package, is it? What you've told us about the Church of Norway shows that yet again there are other ways of doing this, other ways of trying to square the circle and balance the Church's calling to be prophetic and to serve the nation and its people. So yeah, thank you for all that you've put in to this evening. I've enjoyed it very much indeed, and thank you to all who've attended on this this Easter week evening. Anybody who's here who isn't a member of the Ecclesiastical Law Society, do go to the website and consider joining, and you'll also see there the other events in person and online that we've got coming up in the weeks ahead. We've got some online events actually quite soon in the next few weeks, so do go and have a look at our website for that. But Andreas, thank you so much once again, and look forward to seeing you soon in the future. Good night, God bless.
Thank you.